Some of that was true. Well, good morning, everybody. Good morning. You know, I love coming here, love coming to Masters because everybody's awake in the morning, pretty much. As I started preparing for this morning, I naturally thought, gee, what am I going to talk about? And then I realized immediately there's always a ton of different things going on. In California, more than most states, there's a huge amount of legal development every year. And to give you an idea of the numbers of things that the California legislature changes every year, anybody take a guess how many new laws we have as of January 1, 2013? Just the California laws passed in the last year.
4,000.
Well, very close. 876 new laws, which is a gigantic number, and about 300 federal new laws. So there's always plenty of new material for me and for you and people to sue for and defend lawsuits for. And so I'm going to talk with you about a few of those things this morning. 7 things you need to know about real estate and business in 2013. First thing, I want to talk about legal entities, because you see references in purchase agreements and leases to different kinds of legal entities all the time. LLCs, LLPs, LPs, DBAs, trusts. And each one of these things is a different way of formation. Usually they're formed at a California state level. Sometimes they're formed in other states. And the things to look for, the biggest sets of issues that you got to evaluate when you're trying to decide on one of those is, number one, tax issues, because the tax implications are different depending on which kind of entity it is. Number two, liability protection, because if you are doing business in an entity such as a corporation, limited liability company, and some of these other kinds, a limited partnership, for example, the entity that's liable for contractual obligations is that entity, generally not the individual or the principals who own it or who are operating it, unless they behave badly. If individually they behave badly, they can be held liable. But otherwise, contractual debts for sure are the responsibility of the entity, not of the principals. On a tax level, there are substantial differences. The simplest operation of a formal entity now is probably a limited liability company. It's treated for tax purposes as a partnership, which is a good thing, as opposed to being treated as a corporation, which is a more complicated thing. There are S corporations, there are C corporations, and that's really a federal tax issue more than it's anything else. Generally, up till now, you cannot do business in a limited liability company in a professional kind of a practice. So a realtor cannot do business as a limited liability company. A lawyer or doctor cannot do business as a limited liability company. Corporations are more traditional, and they can be used for most kinds of professional practices, a professional corporation, but not a limited liability company, with only one exception, which is contractors as of the beginning of 2013. So when you see references to these things, your clients deciding that they're going to purchase real estate, for example, real estate can be purchased under any kind of an entity, subject to getting financing. A lot of lenders will not lend to a limited liability company. They want an individual and an individual social security number on the hook. But legally, any one of these entities can buy or act as a landlord or operate or sell their own real estate. Just not doing that as a professional on behalf of somebody else. One of the gifts that Congress and the California legislature have given us, and when I say gift, that means people who like to get into very complicated kinds of things and analyze other people's stuff. One of the gifts is in the area of estate planning changes that are effective January 1, 2013. You may remember at the end of last year, the end of 2012, we went through all of the annual entertainment and games at a federal and a state level on the question of how are estates and gifts going to be taxed. So the short answer to this is Congress has now fixed this supposedly permanently. There's no such thing as a permanent fix because they revisit this stuff periodically. But from a tax standpoint, which is one of the big issues you look at when you're looking at estate planning and financial planning, from a tax standpoint, it's now pretty simple for most families. Now, that's not to say they don't need proper professional estate planning, because they do. Things are not automatic. The desires that a family have for how they want their real estate or cash or investments to be passed along, or perhaps they have special needs members of their families or want to take care of ensuring that their kids or grandkids get to college or handle other things. Those are not automatic things. But the tax side of this is that there's now no federal estate tax or gift tax on an estate or gift of up to $5.25 million. Obviously, that takes care of the tax side of most people's planning. And the $5.25 million was enacted as $5 million, but it gets indexed on an inflation track. So at the moment, it's $5.25 million as a combination of what people make as lifetime gifts and assets that they leave when they are deceased. And assets mean assets net of debt. So it really means equity in the case of real estate or other kinds of investments. It doesn't matter. They have $20 million in assets. If they have $19 million in debt, then it's a $1 million estate. In addition to that, anything that's left to a surviving spouse does not count toward the $5.25 million, and anything that's left to a recognized charity does not count toward the $5 million or $5.25 million. So estate planning is as important as it always has been, because most families have more complicated situations than Ozzie and Harriet, for those of you who watch old-time TV. Most families are more complicated than that, with multiple marriages or non-marriages or kids in various kinds of circumstances. So the short estate planning changes are what I mentioned, plus the tax in excess of that is about a 40% federal tax. There's a 40% estate tax or 40% gift tax to the extent that you leave assets through an estate, whether it's left in an estate that's probated or trust or most life insurance, or through some other means, or you make them as lifetime gifts. The tax on the excess over $5.25 million this year would be about 40% tax, and in addition, there's an annual exclusion amount that used to be $10,000 per donor or per donee per year. So if it's a husband and wife, $10,000 for the husband, $10,000 for the wife, per each person that they give anything to. But the $10,000 has been indexed over time for inflation. For the year 2013, it's a $14,000 exemption amount. So for most people, estate planning really is an important issue. If they've got an estate plan, they need to revisit it. Most people are just not going to be tagged with much of a tax, and if you leave this life having to pay an estate tax, that's a good thing, because that means you left more than $5.25 million, or a married couple, left more than $10.5 million combined. Also on the subject of tax changes, we've had some significant changes at both a federal and a state level, and that is, number one, that the maximum bracket for federal income tax has gone up to 39.6% income tax, but in addition to that, the tax rate for capital gain and dividend income has gone from 15% to 20%. This year, the capital gain and dividend income tax is 20%, but that depends on the person's adjusted gross income. It's up to 20%. And at a California level, we have now enacted, the legislature, I don't want to take any credit for increasing taxes, they have increased taxes to a maximum of 10.3% California income tax. Now, for those people who still have any net income left after they pay the increased federal and California income tax, there's also a new 3.8% tax, which is for the Affordable Care Act, or Obamacare. That funds some of the Affordable Care Act, and specifically what that 3.8% means is that for the first time that now applies to dividend and other passive income as opposed to earned income. 3.8% has been there for many years for tax on earned income, but not on investment income. So now the government has increased that to 3.8% on passive income as well. And in addition to that, we have a payroll tax increase for working people. Basically, this will affect working people, and that means the federal tax employee portion of FICA, of payroll tax, has gone from 4.2% to 6.2%. So that's a real 2% increase annually on working earned income, working person earned income. So I always like to make things happy. Have I succeeded so far in bringing you up to that? If you've been watching the news in the last couple of weeks, a very large item in the news has been the U.S. Supreme Court's hearing last week of 2 different days of oral argument on the question of Proposition 8, which is the California proposition that got rid of same-sex marriage, which we had about 6 months of lawful same-sex marriage in California based on a Supreme Court of California decision. California voters then passed Proposition 8 that changed the state constitutional definition of marriage to say no, marriage is one man and one woman, and that case has gone up to the Supreme Court. The U.S. Supreme Court has heard a day of oral argument, but it's really much more than a day. It's an enormous amount of input from different kinds of interest groups, pro or anti, or different people with different kinds of opinions, or groups, individuals, everyone. What I'm going to mention is a couple of things, and my comments have nothing to do with the politics of this. That's going to end up the way it ends up. The U.S. Supreme Court, if they make a decision changing things, or if they, or whatever decision they make at all with respect to the case that was argued last week, that decision will come out in June of this year. It's always difficult to read tea leaves, including what the U.S. Supreme Court is going to do. What I want to mention is that there's a difference between California purposes and federal purposes for same-gender couples. California, we have about 6 months worth of people who were married who are same-sex couples, and they remain lawfully married. If they were lawfully married during that 6-month time, or if they were married lawfully in a different state or country where same-sex marriage is lawful, and they move to California, California recognizes all of those people as married. But in addition to that, California has something called registered domestic partnerships. A registered domestic partnership is is 2 individuals, and the 2 individuals either have to be same gender, who are at least 18, and then to become a registered domestic partnership, you file a form with the California Secretary of State, and you are a registered domestic partnership. If you do that, then for California legal purposes, including tax, survivorship, hospital visitation, child custody, everything, every single issue in California law is the same for a registered domestic partnership as it is for a married couple. Period. No exception. Now, that is not true for federal law. So obviously we have two different structures. For federal estate tax, or for federal income tax, or for Social Security benefits, or for any other federal program, currently the Defense of Marriage Act, which passed during the Clinton administration, it passed Congress and it was signed into law by the President, that says that for federal purposes, a same-sex couple cannot get any kind of federal benefits. So it changes the consequences, for example, on an estate where one of the domestic partners leaves a large estate to the other domestic partner. You could very well end up with a federal estate tax, even though if it were a married couple, recognized for federal law as a married couple, there would be no tax. So there's a companion case that has gone through the U.S. Supreme Court, and that is the case of the Defense of Marriage Act, to decide whether the Defense of Marriage Act is constitutional. And like I mentioned with respect to the Proposition 8 case, the Defense of Marriage Act case will probably end up with a decision out of the Supreme Court in June of 2013. You know, stay tuned to this channel for the next announcement in June. Whatever you might think the Supreme Court is going to do on any given subject, they tend to surprise people. People who are, carefully watch issues. Complicated set of issues, we'll find out. Sometimes they make decisions pro or con. Sometimes they boot cases back to the Court of Appeal because they don't want to make a decision. That's just the way it is. I also want to mention that with respect to registered domestic partnerships, I said that any two individuals over 18 who are not married and who are not already in a different domestic partnership can become a domestic partnership if they are same gender. But if they are not same sex, you cannot then become a registered domestic partnership unless one of them is eligible for Social Security regular benefits. So you could have a person who's 65 and a person who's 18 become a registered domestic partnership, but you could not have two 25-year-old opposite sex individuals become a registered domestic partnership, because the reason California enacted registered domestic partnerships in the first place was because when married couples, when one of the spouses in a married couple who has worked his or her whole life dies, the surviving spouse gets survivor benefits if they qualify. So that cuts off if a surviving spouse remarries. The surviving spouse who would have been eligible to get Social Security survivor benefits, widow or widower benefits, remarries, then that cuts off permanently that person's ability to get Social Security benefits based on the working life of the first deceased spouse. So California enacted the registered domestic partnership law in order to deal with that, so that you could sort of have marriage light, that for moral or for cultural or for personal philosophic reasons you could feel you were married, effectively married, but it wouldn't cut off Social Security benefits. That then got morphed into same-sex registered domestic partnerships, and now the rules are the same, except that the other rules are the same, including, for example, community property. If you have a registered domestic partnership, I said every single California purpose they are treated the same as married couples. That includes community property. So if one domestic partner works, the other domestic partner does not work, the one who does not work has a community property interest in all of the income of the one who does work, and a community property equal interest in any real estate or investment assets or anything else that is acquired with the earnings of the person, the registered domestic partner who is working. It's the same benefit or not benefit, however you want to look at it. It is the same. The exception to what I just said is that you can have a prenuptial agreement whether the parties are spouses in a marriage or domestic partners in a registered domestic partnership. You can have a proper prenuptial agreement that says that we will not treat all of our income or all of the things that we acquire with that income as community property, and that the one who's working will keep the half that she or he has, or I should say the entire earnings that she or he has earned, or whatever is acquired with those things. You can't do this. This is not a do-it-yourself kind of a process. You have to get this done properly if you expect that it's going to be enforceable. When I say you, obviously mostly this is an issue of relevance to your clients, and so I'm certainly not suggesting that you start giving them legal advice. It's for purposes of sensitizing you to issues so that you can discuss them with your clients. Now, just like parties, any parties who are going to buy a piece of property or acquire a piece of property together, there are implications of owning real property when you are a couple, or when you maybe buy a piece of property with your cousin. There are rules that apply, and sometimes people deal with this and sometimes they don't. You have to deal with questions of what your expectations are, the parties, either when they don't get along anymore, and you call that either, if they're married or a domestic partnership, you can get a dissolution, or divorce in some states, or what happens when one dies. And that's a function of how you held title. Holding title together is not a method of owning title. You can hold title as tenants in common, or as joint tenants with right of survivorship, or in the case of a married couple or a registered domestic partnership, you can hold title as community property, which has been the law of California for at least 150 years. And you can also now hold title as the newer and improved community property with right of survivorship. They are different, not from a standpoint of who owns what, but on the standpoint of what happens if one of the parties wants to change their mind on how they hold title. Community property with right of survivorship is more complicated than regular community property. Community property, which is the automatic result if a married couple acquires real property, or a domestic partnership, registered domestic partnership, acquires property using funds that were earned by either one of them during that relationship, then the automatic result is that it's community property. But with community property, either spouse or either domestic partner can will away his or her own half of the property. So if you have a couple, Mr. and Mrs. Jones, Mr. Jones can end up leaving a will, leaving his half of the community property to his aerobics instructor. And if you think about it, that could be the kindest gift that Mr. Jones ever leaves to Mrs. Jones, because one day she's the grieving widow, and the next when she gets a knock on the door from the aerobics instructor saying, "Hello, I'm your new half owner of the property," Mrs. Jones would be able to get over her grief rather quickly. Community property, regular community property, means that either spouse can will away his or her half interest in the community property. Community property with right of survivorship is not that way. So if you title as community property with right of survivorship, neither spouse can effectively leave the property to anyone else, or his or her half of the property. With community property, each spouse is entitled to his or her half, and at the death of the spouse, receives the deceased spouse's half of the property, unless the deceased spouse left it to someone else in a will, and what I just said is not true if it's community property with right of survivorship. So have I tried to make that as complicated as possible? It's the simplest version that I can do of that. The rules for what happens to your property, either in the event of a divorce or dissolution, or in the event of a death, are enormously complicated. You may not like those results. Many of you have had experiences with family or friends who got a strange result when one died or when one got a dissolution, and that's usually or often the result of not planning things out appropriately. If you plan things out and you properly document things and get to a capable estate planner or attorney to handle all of this, then you are more likely to get the results. And when you hear people complaining about how it's somehow the governor's fault that they didn't get what they were supposed to get, that really translates as they did not have a trust, they didn't have a will, they didn't properly plan out what they wanted to happen. A couple more things I want to mention. Most of the state regulatory and federal regulatory rules that apply to real estate apply to 1 to 4 family residential property. And in general, the federal government and the state of California have left their large grabby hands, have chosen not to regulate on the subject of commercial property. There are exceptions to that, and we have 2 new exceptions to that in California. One of them deals with energy use disclosures. So now we have something called energy use disclosures under Assembly Bill 1103. Now this is going to phase in starting July 1, 2013. It's going to phase in 3 pieces: July 1, 2013, January 1, 2014, and July 1, 2014. And the phase-in really is over what properties are going to be covered by this rule. This rule, which is a California statute, says that the seller or lessor or owner who's refinancing property, financing or refinancing, has to make disclosures of energy efficiency. Starting July 1, 2013, this will apply to properties where the whole property is being sold or leased or financed, and the property is over 50,000 square feet. If the property is over 10,000 feet, then that will take effect January 1, 2014. And if it's over 5,000 feet, it will take effect July 1, 2014. So take a look, be on the lookout for this issue. It's going to be it's a mandatory disclosure item as to energy efficiency. So that is in about 4 months from now. 3 months from now, July 1, 2013, any building of more than 50,000 feet that is being sold, leased, or financed, and then the disclosures have to be given. And 6 months later, January 1, 2014, anything over 10,000 feet. 6 months after that, anything more than 5,000 feet. The other piece that I want to mention on here is we have Senate Bill 1186, which will take effect July 1, 2013, and which says that if you're selling a commercial, non-residential property, now you have to disclose which is going to be a written disclosure, whether the property has been inspected by a certified access specialist. So now you can